The case involving classified documents at Mar-a-Lago did not come to an end through a trial in open court. It concluded with a simple legal filing. No jury was ever selected. No lawyers presented opening arguments. No witnesses appeared to testify or dispute the materials recovered from the property. The entire prosecution wrapped up after the Supreme Court issued its decision on presidential immunity, prompting a motion to dismiss the charges. This kind of procedural close has generated its own set of complications, and those issues continue to develop even now. To make sense of the current situation, we need to step back to August 8, 2022. On that date, federal authorities carried out a court-approved search at Mar-a-Lago. Court records later showed that agents recovered more than 100 items bearing classification markings, some designated as top secret and others involving sensitive compartmented information. The supporting paperwork for the warrant outlined reasonable grounds to suspect that information related to national defense had been kept improperly. That operation resulted in a formal indictment containing 37 counts. The accusations included breaches of the Espionage Act under 18 U.S.C. Section 793E, in addition to charges tied to conspiracy and obstruction of justice. According to the government, after a grand jury issued a subpoena requiring the surrender of classified items, certain boxes were relocated. A later version of the indictment strengthened the obstruction claims, asserting that steps were taken to hide materials from officials and to provide misleading information about what was still present at the location. Those obstruction accusations carried significant weight. In practice, charges focused on interference often present more serious consequences than the original possession offenses, since they point directly to deliberate actions. Yet the matter never advanced to a full trial. Following the Supreme Court's guidance on the limits of prosecuting a former president, the Department of Justice filed to drop the case. The dismissal rested entirely on legal and constitutional grounds, not on any retreat from the facts alleged or any admission that the evidence was insufficient. The charges were removed from the court's active list, and for much of the public, that appeared to mark the conclusion. What continued, however, was the special counsel's duty to prepare a comprehensive final report. Federal rules require special counsels to deliver such a document to the Attorney General, detailing the reasoning behind key prosecutorial choices. That report has been finished. It consists of two main sections. The first section covers the inquiry into election-related matters, and parts of it have been made public. The second section deals specifically with the classified documents investigation, and it has stayed under seal. This sealed portion has now become the center of fresh legal disputes. Several watchdog groups and advocacy entities have submitted requests asking the court to unseal and release that second volume. Their core position is clear and direct. The case ended because of a constitutional protection tied to immunity, not because the evidence fell short or the claims lacked merit. As a result, the public maintains a valid stake in learning the investigation's findings. They maintain that openness strengthens public trust and official accountability. The Department of Justice has opposed complete release. In its court submissions, the department stresses important institutional factors. Making public a detailed account of prosecutorial thinking without the benefit of a contested trial could unfairly influence any potential future actions and compromise basic standards of fairness. Additional worries involve the protection of still classified material and the traditional secrecy surrounding grand jury proceedings. These points appear directly in official filings before the court. The action has shifted away from a potential jury trial and into appellate arguments and written briefs. The central issue today is not whether classified items were located at Mar-a-Lago. That reality was confirmed through the search inventory and the original charging documents. The real debate concerns whether the special counsel's unreviewed findings and assessments deserve to be shared publicly. This question carries real significance. Obstruction allegations depend heavily on proving purposeful conduct. The updated indictment described the relocation of boxes following the subpoena, the submission of inaccurate statements, and deliberate efforts to hide evidence. None of those assertions faced cross-examination in public or evaluation by impartial jurors. Should the sealed volume include in-depth summaries of witness statements, internal discussions, or evaluations of reliability, its contents could significantly influence how history views events at the residence during that time. A clear tension exists here. One principle holds that every person is entitled to the assumption of innocence and the opportunity to challenge accusations in open court before judgments solidify in the public mind. On the opposing side stands the view that when constitutional rules prevent a trial from occurring, not due to weak facts, the investigative findings should not remain hidden, leaving important questions unresolved for the American people. Judges will ultimately need to strike a balance between these competing concerns. This stage of the matter is drawing particular attention. Several key elements stand out. First, the matter of standing. Do these external organizations possess the legal right to step in and push for disclosure? A negative answer on that point could halt progress before deeper review even begins. Second, the breadth of any release. If unsealing is approved, would it involve only portions, extensive blackouts, or perhaps a condensed overview rather than the full text? Third, handling of sensitive classifications. Sections of the report almost certainly discuss protected information, so any disclosure would demand careful multi-level decisions on what can safely emerge. Fourth, the lasting impact. The resolution here will help shape how future special counsels manage similar high-stakes inquiries involving senior government figures. Many people believe that when charges vanish from the docket, the entire episode closes. In the world of federal law, that rarely proves true. A dismissal grounded in constitutional immunity leaves the underlying investigative material intact. It simply redirects the conflict, from courtroom evidence testing to battles over access, claims of privilege, and negotiations among institutions. Without a jury verdict, uncertainty lingers. That uncertainty builds pressure. In prominent federal matters, such pressure seldom disappears without resolution, especially when a sealed document holds the government's final analysis of motive, actions to conceal, and overall decision-making, details known only to a limited group. This ongoing effort to obtain the second volume is not mere political theater. It represents a careful, step-by-step legal contest. At its heart lies a fundamental issue. When constitutional barriers stop a criminal case from reaching trial, should the full investigative account stay confidential, or should it become part of the public record? Federal courts handle such matters with deliberate caution. Grand jury information receives strict safeguards under Rule 6E. Classified details fall under specific laws and executive directives. Internal prosecutorial analyses typically remain private. The Justice Department contends that distributing an elaborate explanation of charges outside the traditional trial framework risks unjust damage to reputations. Advocates for openness respond by pointing to the very purpose of special counsel rules. They exist for cases that generate exceptional public concern. When a trial becomes impossible, the final report stands as the most complete statement of what authorities believed they could establish. This discussion does not aim to retry the original charges. It focuses on establishing an accurate institutional record. Recall the key claims in the later indictment. It outlined deliberate relocation of materials post-subpoena, pointed to video evidence, and linked specific counts to alleged hiding efforts. Those elements were designed to demonstrate conscious wrongdoing far beyond simple careless possession. Proof of intent separates viable obstruction cases from others. If the sealed section provides greater detail on how prosecutors weighed indicators of intent, drawn from statements, records, or electronic data, its release could either confirm or challenge common perceptions of the events. That explains the importance of this disclosure debate. Once made available, even with portions obscured, those assessments enter the permanent historical record. They affect scholarly work. They guide legislative review. They contribute to broader legal study of executive authority and document handling. Courts recognize these broader effects. Judges must carefully compare individual fairness against the value of systemic openness. They assess whether targeted redactions can sufficiently guard sensitive details. They evaluate if the broader public benefit surpasses any risk of unfairness. Timing also plays a role. Appellate processes often stretch over months. Reviews for classification concerns extend further. Each postponement lengthens the period of doubt. Each delay heightens the impression that critical information remains out of view. From the government's standpoint, resisting release aligns with standard practice. Prosecutors build cases for presentation in court, not for unchallenged distribution in reports. Their approach prioritizes the tested adversarial system. When that system halts prematurely, however, the report serves as an imperfect alternative. Should a court mandate disclosure, anticipate multiple layers, significant redactions, overview sections, and perhaps judicial notes clarifying limits. Such partial releases could spark further disputes over the adequacy of those restrictions. If release is denied, the document persists in official hands. Future leaders might examine it. Congress could seek it through oversight powers. Dismissal, in short, did not remove influence. It merely postponed its exercise. A larger constitutional aspect deserves note. The Supreme Court's immunity decision set clear limits on criminal actions against presidents, but it left untouched the executive branch's responsibilities for openness following an aborted probe. That opening allows courts to interpret and fill the space. Their rulings could establish expectations for how similar inquiries conclude when trials prove unfeasible. Several indicators will prove telling. First, whether external parties secure standing to pursue the matter. If not, the effort may end on technical grounds. Second, the court's articulation of public interest. The wording will reveal whether openness is treated as routine or exceptional in these circumstances. Third, if classification issues emerge as the primary obstacle, extensive blackouts may follow. Fourth, any congressional moves for independent access could introduce additional executive judicial friction. This process lacks dramatic flair. It proceeds methodically, yet steady federal litigation can quietly alter long-standing practices in enduring ways. The original indictment once focused on physical boxes, security labels, and claimed relocations after official demands. Today, attention centers on a protected report and rival views of responsibility. No follow-up search occurred, no startling admissions surfaced in court. What exists is a sustained procedural contest. In federal proceedings, such contests frequently endure longer than the charges themselves. The result will not settle questions of punishment. It will settle authority over the story, who ultimately describes the investigation's conclusions. The lack of a trial left that authority unresolved. The current push for transparency may settle it. Through whatever form, full release, edited versions, or sustained confidentiality, the court's eventual decision will close this chapter. And in federal cases, final chapters tend to emphasize lasting principles over temporary attention. Let me know if you'd like the next segment to examine appellate tactics, the classification evaluation steps, or the wider effects on upcoming special counsel efforts.